All right, guys. Good evening. I hope you guys are well. Please confirm if you can hear me. Please confirm if you can hear me. You can send thumbs up. You can unmute and tell me you can hear me. All right. I see. I can be heard. Okay, so we want to welcome you guys for this session. And we want to thank God for giving us the opportunity to have, to convene here and to be able to have these sessions and to learn from each other. I think it's a very great opportunity. It's a very great opportunity for us to have you, and I also want to believe that it's a great opportunity for you guys to to have us. And I want to believe that ever since we started these sessions, today is our 8th session. I want to believe that we've learned much, and that we continue to learn each and every day. I want to believe that we continue to push ourselves, and we are only getting better. So as usual, I'm going to start us off with a word of prayer. So kindly allow me to pray. Our Father, what in heaven, Lord, we thank you so much for this evening. We thank you so much for this platform. We thank you for each and every soul that has joined us this evening. King of Kings, as we discussed today, may you open our minds. May you lead us and guide us, Lord. We surrender this platform to you. We surrender this meeting to you. May you have your way. May you open our minds, King Jesus. May we come out of this session learned. King of Kings, may you help us to remember. May you help us to understand. It is in your mighty name that we pray and believe. Amen. Okay. So this is how we always start. This is how we always begin each and every day. And so I think that's something that we have to get used to. So as per usual, today we are going to start by questions from you guys, but general questions. Let's try our best and maybe use the first 15 minutes to ask these questions before we can begin. But I want to believe that by now, so many of these questions have been answered, and I want to believe that by now we're not anxious about how orals is. I want to believe that most of the general questions have been answered from one person or another. So if we have any, I think the last time we were finishing, we had a few questions from a few people who weren't able to ask their questions. I can't remember your names, but please, you can just raise your hands right now so that we're able to deal with those questions as fast as possible before we kick off, before we focus on the reason as to why we are here this evening. Again, you are all welcome. Please feel free. Feel at home. This session is being driven and directed by students just like you. We went to KSL. We've gone through the journey. We know how it is. We know how orals can be crazy. We know how much there's so much anxiety concerning orals. There's so much myths being shared out here concerning orals. People talk about ambulances. People talk about this and that this is not possible. But we are here to tell you that it's possible. There's nothing that is impossible. People have done it. Some people have gotten 20. They've been given 19. The people who have gotten 3, people have gotten 7. Again, it depends. Everyone makes their own story. So please, if you have any general questions that you'd like us to answer, this is the time. This is your time. If your hand was raised last time when you were finishing and you aren't able to ask your question again, this is the time. Let's ask those questions as fast as possible so that we're able to move on to the next level. Any questions? Any? If we don't have, then I think we're just going to begin straightforward. Any questions from anyone? Now or forever hold your peace. Any general questions from anyone?
I have a question.
Okay, kindly
Yes.
put up your hand for the purposes of order, if you can.
Okay. Let me just raise it.
Okay, now go ahead.
Yes. Okay, my name is Ochieng, and I have a question on resealing of grant. That's Section 77, the Law of Succession Act. Lecturers seem to have different views on what goes on when one needs to reseal a grant, especially when it comes to now, we know it's all about foreign property that's in foreign land. So Madam Ruto told us that it's so easy, it's very clear that once one gets a confirmed grant, for example, in Kenya, and you need to, and the property is that the property in question is in, let's say, England, that is. So you just once you, as an administrator, you just go with the confirmed grant in Kenya, and then that's been confirmed in Kenya. You go with it to a law firm in England, and then then the lawyers there, what they'll do is that they'll petition the court for the sealing of grant, and it is once that happens, then you'll be good to go as an administrator dealing in that property. And then today, Odera now, Tony Odera in his class, he just said that one needs to start a whole process of petitioning for a new grant to deal in that property in that foreign country. So based from what you know, or from what you've been taught before, which one stands? So there seems to be confusion there. Which one will you advise we go with? Because now we attend this, we do attend these different lectures, and they have different stands on different issues.
Thank you, Hilary. Thank you, Hilary. Yeah, those two are my seniors. I don't think I'd be a judge in that particular scenario, but maybe something real quick. For us, we were taught by Mrs. Ruto. So because we were her students, they say when the student is ready, the master appears. We went with what she told us was right. I mean, she was our lecturer and she was the one teaching us. So we went with what she told us was right. Now, I know even Section 3.5 of the Law Succession Act, we have so many debates around it. We have so many opinions around it. So, okay, for me, I'd go with what my lecturers told me is proper. Again, I mean, these are my seniors. I can't tell you that this one is wrong, this one is right. But I think it's safe to go with, what your lecturer has told you. Yeah. But apart from this, I think Hesbon, yeah.
Yeah, but what happens in such an instance? Let's say, for example, okay, for orals at least, not orals, okay, for project work, let's say such a question comes up, then that will be a matter of who marks your project work. But what if now it's in orals and in the exam, and your lecturer is not there in such a question on what they are contradicting each other on? What do you do in such an instance as a student? Because you never know who's going to ask you questions anyway.
All right. Now, this is a trick that you were taught when you were in KSL. For example, Section 3.5 depends on who has asked you that particular question. So it's proper and safe for you to know both sides of the story. If you're able to know both sides, then if I'm asked by Mrs. Ruto, I'll tell Mrs. Ruto what I know Mrs. Ruto says is proper. If I'm asked by Madam Anastasia, then I'll say what she thinks is proper. Yeah. Anyway, okay. That's what they know is right. Yeah. So it depends on which lecturer has asked to go. Then I think Hesbon also had something to say. Hesbon, I think you can go ahead.
Yeah, it is Angelo.
Okay, thank you so much, Bwana Duore. I just wanted to maybe shed some light to the question that has been asked. It's a very good question. So now, I think I was also able to, I was guided last year by Miss Anastasia, but I also attended some classes by Miss Ruto on the same topic. And I think on this one, they actually read on the same page. And also, if you actually look at Section 77 of the Law Succession Act, it is the one that speaks about the sealing of foreign grants. So this is what I'll tell you guys to know, that every country has got an act that regulates their succession. So in Kenya, we know that it is LSA, the Law Succession Act. Then now, another thing to also know that, so every country that has got Law Succession Act has got a provision in that act that prescribes how that act is going to deal with the grants from foreign countries. So for example, in Kenya, Section 77 says that if there is a foreign grant, then Kenya shall reseal that foreign grant by Section 77. So now, towards your question that you asked, that if you have, for example, you have some property in England and you want to administer over that kind of property, the first thing you to do is you, of course, first subject yourself to Section 4 of the Law of Succession Act to know, like, is that property, which law is applicable? Is the Kenya law applicable, or is the England law applicable? So, of course, you know that if it is movable property, then you know the situate of that property is what determines which law shall be used. If it's immovable property, then the country of domicile of that person. So your question now was actually regarding that this person is domiciled in Kenya, and he has like a property that the law of Kenya shall apply. So meaning that this grant shall be applied in Kenya. So once you get this grant, you go to the country where you want to administer over that estate. So let's say the country is England. So once you get to England, you cannot, of course, you know, like you do not have authority to rather practice there. So what will happen is you'll identify a law firm. Which law firm is going now to ensure that the grants from Kenya, the one you hand them, are actually resealed. And you know that England has an act that is equal to the Law of Succession Act of Kenya that has a provision on the procedure of resealing the foreign grant from Kenya. So you won't need to go through the entire process of again applying for a new grant in England. The Kenyan grant shall be resealed in that country. So that is the position by Ms. Anastasia and also for Ms. Ruto. And I also have actually interacted with some in the real practice, and that is really what happened. I will not dispute the other position you said, but at least from the two sides of those two probate and administration lecturers, I think it's proper we go with that. Thank you.
Thank you, Oko. That was what I was trying to tell. You know, I'm a member of Class A, so I'm a Ruto is one that teaches. But now, when I was in that class following up, then that confusion arose, and then I was trying to explain to my student and to my colleagues what Ruto said, because actually she just explained the same thing you said, and she was so direct and clear that Section 77 is so direct that one does not need to apply, you know, for the whole process to get a new grant. But now it wasn't Anastasia, it was Tony Odera in the morning today on Saturday. That's why I thought I should ask that one. But personally, I think what she explained and what you explained is just as direct as that, no complications.
Okay.
Daniel.
Yeah.
Yeah, this is Angelo.
Go ahead, Angelo.
It is just to reiterate what my colleague said, that is Honorable Oko. We were actually in the same class. I believe there's no dispute about Section 77 because that one applies to grants from outside that are actually needs enforcement in Kenya. That is resealing by the High Court of Kenya. So you will just go to the High Court. Once it is resealed, then it will follow the normal procedures of execution of any grant. So that is with regard to Section 7. However, now Section 4, it has two aspects: the movable and immovable. Whereby immovable, it doesn't matter. The law of Kenya will apply to immovable property. However, if you look at Section 4(1) paragraph B with respect to movable property, the law of that particular country will apply. That is, for example, is it Tony Odera or that lecturer that you say? So if it is a movable property, then actually you will have to start a whole process that is in England where that property is situated. So what you will do, since you are not qualified to practice there, or by virtue of the fact that you are a Commonwealth, maybe there will be some kind of certification that will be required. So you will start a new process that is with regards to movable property. But if it is immovable, then it is the laws of Kenya that is going to apply. That is, if you look at Section 4(1). So that is what I wanted to clarify, Daniel.
Thank you, Angelo.
Good evening, Daniel.
Good evening,
Daniel. Yeah, so I'm the presenter who actually presented on resealing today in the morning. And from our research, of course, just as Angelo has said about resealing in Kenya, there is also law and rules that govern resealing in England. Like one of them is non-contentious probate rules of 1987, and it provides for resealing. So this property was in England, and first of all, this property was not part of the property listed in the schedule of assets when letters of confirmation of grant were given. So it was a newly discovered property. First of all, we differed on how to approach the court in such scenarios. The lecturer was of the opinion that we are supposed to go with section 74, which is rectification. Most of us were of the view that you approach the court through a review of orders, and that can only happen when you import order 45 of the civil procedure rules through rule 63 of the probate and administration rules. So we tried to compare how we reseal and how England reseal. And we were trying to tell the teacher that we don't need to go to England to start a new process. We were of the view that we just need to apply for review of orders so that we get the property, listed in the schedule of assets, and then we look for lawyers in England, give them power of attorney, and allow them to apply for resealing of that grant so that it can have the same force as if it was granted in England. And for me, that is the procedure provided in Rule 39 of the non-contentious probate rules of 1987 of England. But the teacher was also of a different opinion. So maybe it is something that you guys can also research, and maybe next time or even within this discussion today, you may also just weigh in and give opinions. Thank you.
Thank you. Thank you. I think time is well spent. Thank you, Pius. Thank you so much, Hilary. Thank you, Angelo. And thank you, Hesbon. Yeah, just to cap it off, guys, whatever is right is always right. Of course, they say that law is never that clear. It depends on your arguments. But again, I'd like to tell you that if you're appearing before Angelo and Angelo holds a particular view on a particular matter, guys, it's safe to go with what Angelo says if Angelo asks you that question. And that if you're appearing before Hesbon, and Hesbon, you know the view that Hesbon holds on a particular matter, it is proper that you go with what Hesbon holds in that particular matter, so that you are not going into arguments here and there, so that the onus is not on you to argue against Hesbon and prove Hesbon wrong. But I also believe that what is right is right, that if you appear before the court, then what makes sense is what you should go for. It's wisdom that can be applied. It's orals. It won't take your knowledge away from you. It won't take what is right. It won't change what is right to become wrong. But again, I don't think you want to rub shoulders with these people. I don't think you want to prove them wrong. I don't think we have the time to do that. But yes, what is right will always be right. Thank you guys for that. Angelo, I hope that's okay. For the purposes of wisdom and just safety and getting done with this and moving on to the next level.
Very correct. Very correct. That is the position.
Yeah. So just get to know these guys. For example, 3.5, we know what Mrs. Ruto says, please. We know what Madam Anastasia says, please. I think you'll have a very quick time. You'll be able to finish off with this and just move on to the next thing. It's not worth it. You'll fight it again when you're appearing before them. And then what? What changes after that? Anyway, just my opinion. Again, I think we have to still decide what we want to go with, but just my opinion. Okay, guys, so it's 8:30, and so we begin. Who is going to be our first volunteer? Our first volunteer, please. Anyone who is ready to volunteer as we begin today? Anyone? Anyone? Any volunteer, guys, so that we're able to begin and move on to the next person? What if we start with a lady today? I think we've had men volunteering for quite a while. Let's have gender parity. Any lady who is ready to start us off? Let's not waste time again, of course. If no one is raising their hand, then maybe it's you should be raising your hand. Just raise it so that we begin. Mildred Nafula, would you mind? Mildred Nafula. As she gets ready, anyone else? Yes, okay, that's Lim. Let's have, okay guys, maybe the ladies are not ready. Lim, you're ready?
I can give it a try.
Okay, Lim, what if we start with Hillary? Is that okay with you?
That will be okay.
Yeah, I think it's his first time. And guys, the reason why Lim keeps getting better and better, and Pius and everyone else, and Donna and Kibi and all these guys, is because they try, guys. They try. Just try. This won't kill you. You make mistakes here, we won't take you anywhere. We cannot record these marks and give them to anyone. It ends here. Just try. Try and see how you'd feel in that circumstance. Try and see what you need to work on. Try and see how you need to improve. The only way to do that is to use this platform. Let's use this platform. So don't be intimidated by anyone. Don't matter the number. When those marks come, they are yours. They won't be mine, they won't be anyone's. So fight for yourself, guys. Don't be scared. That's what I keep saying. Don't be scared. Just don't be scared. Okay, Hilary, you ready?
Let me give it a try today.
Oh, yeah. All right. Hezbollah,
Yeah, I'm ready.
would you like to start?
Okay, I am ready on my side.
Okay. So today it's one person per candidate. So go ahead.
Who is my candidate, please?
Hilary Oduor, I think he's ready.
Yeah, I'm ready.
Okay. Good evening, Hillary.
Good evening to you. How are you?
Good. Now,
Good evening. How are you? Can you hear me?
yes, I can hear you. Now, assuming we are actually having a session in the morning, so kindly introduce yourself.
Yes. Good morning. My name is Hilary Oduor. I'm in class A, a member of Farm 7. Sorry. Good morning. My name is Hilary Oduor. I'm in of registration number 2023-1387, a member of class A and in Farm 7. And I'm glad to be here.
Okay, thank you so much,
Thank you.
Hillary. So I'm going to have a very brief session with you. And the first question to you is that you get admitted in 2020 December, and you really are very interested in
Yes.
getting to maybe have a public litigation. So you get a job at the Office of Public Prosecution, and the first thing that happens
Yes.
is a file is given to you. A file of color red is given to you, and then a police comes in. Police that is going to work with you on that file comes to you and tells you or asks you to try find out the contents of the witness statement by the witness statement that was that was availed to the matter. So there are several files in that cabinet where you're going to have a look at. So which exact prosecution file are you going to look for you to get witness statements? Hello?
Come again. I've lost your phone. I've lost you. at the tail end. Come again?
Okay, the question is, so the police that is assisting you with the
Yes.
matter comes to you. He tells you that he's interested in having a look
Yes.
at the witness statement
Yes.
that was filed for that matter.
Yes.
So there are various files, there are various prosecutions files before you which have been given, named A to J. So which exact file are you going to look
Yes.
so that you get to obtain the witness statement?
That's usually file D. If I'm not wrong, file D is one that usually contains prosecution's witness statements. Yes.
Are you sure about that?
Yes, I'm sure. Yes, I'm sure about it. It's file D.
Okay. Then now, you also develop an interest in commercial transactions,
Yes.
and you get to a top tier firm where they are doing transactions in mergers and acquisition. So an advice is thrown on your side, and you find that there are 3 clauses which are explaining about, or rather, the 3 issues which you are supposed to explain to one of the client is non-disclosure, non-circumvention, and exclusivity clause. How will you distinguish the same, and how are you going to
Yes.
make in a manner that the client is going to understand?
Between non-disclosure, non-circumvent, and the last one, I didn't hear the last one.
Exclusivity clause.
Exclusivity clause. Okay, generally, I know from. Okay, thank you. I know in mergers and acquisitions, I know that before parties get into the agreement, that's the merger agreement, when they begin the process, first they usually need to get into that non-disclosure agreement. Non-disclosure agreement usually entails where parties agree not to disclose any information to any other third parties that could jeopardize or that could jeopardize the transaction at hand. That is, and the rationale basically is when parties are negotiating or discussing and all that, is that crucial information will usually go out and they disclose crucial information about their businesses, about their companies and such. And therefore, there's need to maintain that security of their information so that they don't get to third parties. And when it comes to non-circumvent agreement, non-circumvent now usually intended for use by a company or by an individual that is engaged in the business transaction, but who wants to ensure that, number one, that the identity of the introducing parties or contracts remains confidential and that doesn't go out. Number two is that the other party will not bypass anyway the agreement or anything that they have discussed, so that to go behind their back and start the transaction or to start negotiations with another party at their back. So that's their difference. For non-disclosure, generally no disclosure of any information, about our company or about our business and such. But for non-circumvent is that its rationale is that parties are not allowed to go behind each other's backs to start and negotiate with other parties who are not in this negotiation table. That is, I didn't get the last one that you mentioned. Maybe you can.
Okay, it's okay. You are, that is well. So the second.
But today.
Okay, the second last question to you, Hilary, if you can hear me.
Yes. Yes, I can hear you. Breaking.
Who is your conveyancing lecturer?
Conveyancing is Mr. Ayera.
What was the last topic or last issue discussed in class?
Last topic we discussed, it was a topic on leases, subleases, leases and subleases, sale by leases and subleases, yes.
Okay. Now, I believe you have covered the sale of land, right?
Yes, we have.
What is the understanding of completion?
My understanding of completion is that, as the name suggests, it usually comes at the tail end of a transaction where now parties to that for example, let's say sale of land, deliver their end of their bargains. For example, a vendor will deliver the documents necessary for transfer, that is title, if they sell, if there are clearance certificates and such. And then on the purchaser side, you'll have to deliver for example, the consideration. For example, let's say the balance had already been paid, so that not a balance, a deposit, so they'll be delivering the remaining balance and such, so that now we can begin the transfer process, so that the purchaser's advocate can begin the transfer process. So it just entails everyone delivering their end of the bargain in that sale agreement in order to complete and to begin now the transfer process. Yes. Thank you.
To begin the process. Okay. Now, the last question, I request that you take 30 seconds, because I think we have 1 minute with you. We have 1 minute with you, but I'm interested in this question. Kindly just
you are breaking.
Can you hear me?
Yeah, you're breaking, but I can hear you now.
Okay. So my question to you is, and kindly be brief on this one.
Yes.
Yes. What is the key difference between the completion in off-plan purchase and the completion in this normal purchase, where there is an existing, let's say, land or the asset you're purchasing?
Okay. The main difference is that in the completion in a normal sale of land, and that of off-plan, is that when in the normal sale of land, there is usually normal sale, there's usually handing over, for example, of title, and one can immediately start the transfer process. But when it gets to off-plan, there is no deliverables, but rather it's usually the signing in of that off-plan sale agreement. And then you have to, one has to wait till the development is done for you to now begin the other process of now acquiring the title and all that. Yes. That's my understanding of different.
Okay, thank you, Hilary. Thank you, Hilary. Our time has run out. Odu, if you may allow me to give the feedback and maybe some review just in 1 minute.
No problem, sir.
Okay, thank you. So first of all, I commend Hilary. That was really a good attempt from your side, and being the first person today. The first question you really handled well. It tells me that you have mastered the file from file A to J. You're able to establish that the subfile, the prosecution subfile where you find the witness statement is subfile D. That is very correct. So I'll invite everyone to go read that and master from file A to J. You can be asked about any. The second question I asked you about non-disclosure, non-circumvention, and exclusivity clause. I get to understand that. I think you have read about mergers and acquisition. I'll now invite you to maybe go look at all those stages, because you may get a panel that may ask you to now discuss the 13 steps in mergers and acquisition. They're all the same. The names that the names is what will distinguish them. So that was a good thing. Then the third question was I think was on the completion. The definition of completion, you're right. But then I had an when I asked you about the difference between the completion in off-plan purchase and completion in the other kind of purchase. And there is a reason as to that question. Maybe you should have asked yourself why. You remember that the between the two is that when you are dealing with off-plan purchase, first of all, let me start with the normal purchase. Where normal purchase, once the parties execute the document, let's say, for example, sale agreement, they fix a completion date immediately. So you also know, like the LSA conditions of sale, condition 8 provides for the completion, which can actually be 90 days, or parties can agree, say, let's have this number of days. So they will set the completion once the contract is executed. However, in off-plan purchase, and this is where I wanted you to get it, the completion is usually in future, in future. And completion, unlike in the other normal kinds of sale, where the completion date is fixed once the agreement has been executed, in off-plan purchase, you fix a completion date just after the certificate of the practical certificate of completion has been availed to you by the architecture. So that is when to fix the completion stage. So you should be able to switch those two categories of completion, both in off-plan and the other sides of sale. But it was a good attempt. At least you were confident in your answer, and I like that. Thank you.
Thank you for the feedback.
Thank you. Thank you, guys. Hillary, good job. Okay, our next volunteer. Our next volunteer, please. Yes, Eddie.
Good evening.
Good evening, sir. How are you?
I'm fine.
Okay. So, Eddie, me and Angelo are going to ask you a few questions.
Okay.
All right. So, kindly introduce yourself.
My name is Eddie Nicholas Multi from Class B, Farm 31, currently undertaking my advocates training program. Thank you.
Welcome,
I'm
Eddie. Eddie.
Yeah.
Eddie, you can hear me?
Yeah, I can hear you.
All right. So, your friend Stephen has heard about this term, corporate personality, and they own a company, and so they're interested in knowing the meaning of this. What's the meaning of this word, corporate personality?
Okay, the meaning of corporate personality is the existence, the legal existence given to a company after incorporation under Section 19 of the Companies Act 2015. What it means is that the company becomes a person on its own, or what is commonly called a juristic person, which is a fictitious creation by law, meaning that the company is different from its owners and that the company can do some activities that a human being or a natural person could do, such as owning property, suing and being sued in its own name, yes, getting into contracts on its own, and yeah, and many others.
Okay, all right. So he's also interested to know about this case, the case of Force versus Habuto. What do you know about that case?
Yeah, the case of Force versus Habertol is a case in commercial transactions which established that courts will be reluctant to interfere in the internal runnings of the company. So in this case, it's created three rules, which is first is the is the Indo management rule. Basically, that's that a company will a company's actions or a company's Indo management would be given priority before intervention externally made by the courts. The other issue arising, or the other implication of that case, is that once a company ratifies or members ratify a decision made by the company, then that is considered to have been initially agreed by the company, even if they ratify it afterwards.
Joshua Ogo, kindly mute. Joshua Ogo, kindly mute. All right, thank you, Joshua. So Eddie,
Yeah.
what you're trying to say is that the case of Force versus Habuto is on the Indo management rule?
The Indo management rule arose from that case.
Okay, then what do you know about the case of Royal British Bank versus Tankard? What's that case about?
I might have confused myself, but also we've not done company law, so I'm relying on general knowledge. So maybe there's a mix-up.
Maybe there's a mix-up, or there's a mix-up.
There is a mix-up because the Tankard rule is I can't get it clearly, but Force versus Sabotol, because it's one of what it establishes. That I'm sure what it establishes that once decisions are ratified by a company, courts will be very cautious in interfering with those decisions. And Force the discussion on Force versus Sabotol, the rule is also one of the common law developments that led to the derivative action, which is now a derivative claim under statute. So let me tie myself to only that aspect and not bring in the Indo management rule until I go read
Okay.
afterwards.
All right. So derivative actions is a remedy to the rule in Force versus Habuto. So this is a quote, so end of quote. Could you kindly explain that statement? Derivative actions is a remedy to the judgment issued in Force versus Habuto. What does that mean?
Yeah, what it means is that as I've explained before, in Force versus Habuto is that once decisions are made by the company, or ratified by the members, they are considered to be decisions of the company, which the company had agreed to, and therefore courts will not overturn or will be cautious in overturning such decisions. So the derivative action is an exception which in that it came to aid the stringent application of that rule to ensure that directors, whom sometimes may be the majority, don't get to do actions which may harm the company or are oppressive to the minority, and then just because they are the directors and they are the ones in control, they will just ratify those decisions, meaning that there won't be relief for the company or for the minority. So that's why it's an exception, which means that court can use the derivative action to interfere with decisions made or ratified afterwards by the majority directors of the company.
All right, my last question. Your friend has come to your chambers, and one of the questions that they're asking is that they've heard about this, that the shareholders have the right of preemption or preemptive rights or the right of first refusal as per the Companies Act 2015. What does this mean? The right of preemption.
The right of preemption means that it can also be called the right of first refusal. Means if the company is selling shares, or maybe shares have been forfeited by a shareholder, and the company maybe wants to dispose those shares, or maybe it has treasury shares, the company is selling them. Before those shares are transferred to another party, the existing members will have a right of refusal, which means that they will be given the first opportunity to buy those shares. Thank you.
Last question. What's a private limited company?
A private limited company is a company established under Section 6 of the Companies Act. It's a company owned by private members and whose liability is limited to a certain share amount, capital amount, provided in the statement of So which means that the liability of the members is limited to the extent of that capital bought through their shares, the uncalled capital through their shares.
Can you just repeat that? The last part, that is, liability is limited to what?
The liability of members is limited to the amount of their shares which is unpaid.
The amount unpaid on their shares. Okay, that's proper.
Yeah.
Any three more characteristics of this particular company? Just three. Just three more.
Yeah, the company's shares cannot be sold to the public. Exchange of shares is also prohibited. Transfer of shares are prohibited. The other thing is that the company must end its name with LTD or limited to show that it has a limited type of personality. The other characteristic is that that company may have a minimum of 2 members and the max. It should have a maximum of 50 members.
And a minimum of?
A minimum nowadays there is no. It used to be 2 before, but nowadays it doesn't have a minimum of 2. You can have a 1-member company.
All right.
So it's just
thank you, Angela. Okay, Eddie. Angela.
Okay. Odur, I don't know. Maybe you can give your feedback so that we can have the next volunteer. Maybe I can take over from there.
All right, Eddie. I think your answers were proper. Apart from force versus habuto, and I'm glad that you also realized that, when you talk about the Indo management rule, then you're talking about the Royal British Bank versus Tankard. Force versus habuto is on the proper plaintiff rule. That for a company to bring a suit in court, it means that the majority of the members have decided to bring that suit, meaning the minority wouldn't have been listened to. The majority have it all. Okay. When I asked you about the derivative action being a remedy, and I think this one you got correctly, so derivative actions have allowed the minority shareholders to bring an action against the company, even though this decision has not been made by the majority shareholders or the majority members of the company. Okay, so I think, but again, you kept emphasizing on the fact that it's on, decision, and I think something else that you said. Then the right of first refusal, you got that correct. Just that maybe you didn't explain it more. So where a company is allotting shares, the company must first offer those shares to the existing shareholders. It must first offer those shares to the existing shareholders. It is only after those shares have been offered to the existing shareholders, and those shareholders have refused to take up those shares, that the company can offer these shares to new shareholders. So when we talk about right of first refusal, we're saying that the existing shareholders must have refused to take these shares at first before they're given to any new members. Now, in answering private limited company, you decided to go with Section 6. The reason why you decided to go with Section 6, I'm not really sure, because Section 6 is on limited companies. And I think I was very direct when I asked private limited companies. So I was not just asking you about limited companies, but private limited companies. So I think maybe you could have separated those sections, talked about Section 6, and also talked about Section 9, which is on private limited companies. Then you got the definition correct. The reason why I asked you about the amount of shares, I think you talked about called up shares or uncalled shares or somewhere there. But yes, I think later on you explained that correctly. The meaning of corporate personality, you got that correctly. Yes. Then which other question did I ask you about? Which other question did I ask you about?
I think they were those. They were below.
There are those one, yeah. So I think for me, you did well. I mean, from what I've asked you, you know what's up, you know what's going on, you know what these things are about, and you understand what it is. And I think you're on the right track. Just keep going, just keep moving, and all the best, AD. All the best.
Thank you very much.
Okay.
All right. Thank you, Daniel. I believe we can now have a female volunteer. Our next volunteer, please let us hurry up tumalizane haraka. Can you see someone, Daniel, on your end?
You have Wery Jacob.
Hello, Wery Jacob. Good evening.
Good evening too.
Okay.
I heard you had made a request.
You are saying?
I was raising my hand so that once you're finished with you are making request for a lady. So once you're finished, finished with them, then I can take it. Or if there's no one, then I can take it.
All right. Let me call it once, and then I call it twice, and then okay. Ladies, anyone, please? Come on, you have been dominating these discussions. Okay, I guess there's no one. So now, Wery Jacob, please introduce yourself. Assume that you are taking your orals in the afternoon.
Good afternoon, Mr. Makwe and Mr. Odur. My name is Jacob Oruko Were. My admission number is 2023-1087. I am currently undertaking the Advocates Training Program at the Kenya School of Law. Thank you.
All right. Mr. Were, can you please name 3 ways of attacking a plane?
3 ways of attacking a plane. Thank you for the question. I can attack a plane through defense. I can attack a plane through counterclaim. And I can attack a plane. Sorry, I've forgotten the third one.
No problem. If we may proceed further, please give me 3 ways you can respond to an application.
I can respond to an application through replying affidavit. I can respond to an application through I'm only sure about the replying affidavit. I can also, I'm not very sure, but I can also reply through further affidavit or supplementary affidavit. But I will check on later.
Okay. Very well. Mr. Were, can you please name for me please define for me what is an affidavit and proceed to give me 3 types of affidavits that you know of.
An affidavit is a document which may be used to, number 1, to support the averments that have been made in an application, or it can be used to verify the pleadings that had been made in a plaint. It can be used also to supplement or to further provide information or maybe evidence to the court. The types of affidavits we have are, number one, we have verifying affidavit, we have supporting affidavit, we have further affidavit. Yes, you said correct. Thank you.
Okay, okay. Thank you. Are you aware of the provisions of Article 49 of the Constitution of Kenya?
Article 49 of the Constitution of Kenya provides for the rights of an arrested person.
Are you sure about that? Where time is not on our side, please. Don't be pressured.
Yes.
Very well. Then please give me at least 5 rights of an arrested person.
Thank you. Arrested person has the right to be presented. First of all, arrested person has the right to be informed of the reason they are being arrested on. They have a right to be allowed to access an advocate. They have a right to be allowed representation. They have a right to be presented before the court within 24 hours of arrest, if possible, and in case not possible, then within the next available court sitting. They have a right to be allowed bail and bond. They have a right to be treated with dignity. Thank you.
Okay. You have talked about bail.
Yes.
Can you please give me exceptional circumstances under which bail may be denied? Give me at least 8.
Thank you very much. Bail is a right. However, bail might be denied if the main consideration is if the court presentation by the prosecution shows that the accused is not likely to attend the court sessions. They are not likely to present themselves before the court. That's the main reason. However, we have other reasons which include, number one, bail may be denied if a person is a national security threat. Bail may be denied if a person has gone against the bail and bond agreement before. Maybe they were given bail, and then after being given bail, they also failed to show up before the court. Bail may be denied if the person is likely to interfere with the witnesses. Bail may be denied if there is need to protect the security of this person. Bail may be denied if you said 8. I don't know how many.
You are doing well. I believe you have answered my question.
Okay.
So now I am left with 2 minutes, and I would like you to answer one question, and then my favorite question will come next. Then this is very quickly. Please give me at least 3 types of injunctions that you know of.
Yes.
Don't define, just state them.
Thank you. The 3 types of injunctions are, number 1, we have the Anton Pillar injunction. Number 2, we have the Mareva injunction. And then conservatory orders, it's injunction against the government.
Okay. Now, I would like you to give me the main facts in the Desmond Peters case. Just in less than 1 minute.
I'm sorry about that one. Desmond Peters' case was, I'm not quite conversant with it. I'm not going through it. To be
Okay.
honest about it today.
You're hearing about it today for the first time?
Not for the first time, for the second time. I heard about it today during the lesson we had today, but I'm yet to go through it, but I purpose to go through it within my next reading opportunity.
Okay. There are other two cases that are used to study trial advocacy at the Kenya School of Law. Can you please state for me those two classical cases?
Two classical.
Other than Desmond Peters.
I'm not conversant with them.
Okay. Sawa. Let me give my response. I only have 1 minute left. So now, my first question was the aspect of 3 ways of attacking a plane, whereby you got 2. The only one that you actually forgot was a set off. So I believe someone may come later, will ask someone else the differences between a set off and a counterclaim. So that one, it is an oral examination question. Okay. Then if I proceed further to 3 ways that you can respond to an application, they are provided for under Order 51, Rule 14. That is something that you can confirm later. I'm not sure. But they include the following: that is a replying affidavit, grounds of opposition, notice of preliminary objection. Okay. Then you did really well with the aspect of the provision of Article 49. But your answer was not convincing in the sense that you were kind of not sure whether actually Article 49 provides for the rights of an arrested person, because most of the time we do interchange them, the provisions of Article 50 and Article 49. And yes, you did really well. And it is also a very, very common question during our oral examination, and which include, among others, the right to remain silent, right to be informed promptly in language that the person understands of the reason for the arrest, the right to remain silent, the consequences of not remaining silent, to communicate with an advocate and other person whose assistance is necessary, not to be compelled to make any confession or admission that would be used in evidence against the person, to be held separately from persons who are serving a sentence, to be brought before a court as soon as reasonably possible, but not later than 24 hours after being arrested, or if the 24 hours ends outside ordinary court hours, or on a day that is not an ordinary court day, the end of the next, that is day. That is it. And then there are 2 more. Then to finalize on the injunctions, I believe you did really well on those. We have Mareva injunction, prohibitory injunction, mandatory injunction, Anton Pila injunction. There are a lot of them, very many. But someone will ask you to distinguish between a Mareva injunction, Anton Pila injunction, prohibitory injunction, mandatory injunction, among others. So on the aspect of the bail, you really did well. But now I'm not going to give you facts of Desmond Peters, very, very sweet case. It is something that you need to find out yourself. Then these 2 major cases, actually, if you meet Mr. Moniki and you don't even know them, I don't think you can leave that that examination with good marks, because he's really mean about it. So please find out and study them, because you will also need them in your bar exams. So that is what I can say. There are 3 cases. Okay, one in the Lower Eastern. I'm not going to tell you. Then there is another one near Muizi, and then there is this one of Desmond Peters from the United States. Please don't sleep without knowing anything about those cases. So that is what I can say on my end. I have taken 2 extra minutes. So that is all, unless if you have a question for me, Mr. Were.
Thank you very much for highlighting for me on the cases. I just learned that There's Desmond Peter, Faith Mweni, and I'll check on the third one. Thank you very much.
Yes, please check on the third one. Okay, thank you. Daniel, take it away.
All right, Hezbon, I think you're next. Our next, anyone? Let's have a lady, please. Let's have a lady. Guys, you guys we took over this platform for a while. I don't know who discouraged you. Let's have a lady, please. Not be scared of anyone or anything. Just raise up your hand, and at least let's say that when these sessions are done, at least you appeared once. Any lady, please? Ladies in the house, please, just one of you, so that we have gender parity. Yes, Akumu, thank you for that. Hezbon, you can go ahead.
Okay, thank you so much, Daniel. How are you, Mr. Nyango?
I am fine.
Oh, sorry, I thought it was Akumu. Okay, it's okay, Mr. Onyango, right?
Yes.
Okay. So now we are going to have a very short one. So assuming you're undertaking this exercise in the afternoon, kindly introduce yourself.
Okay, so good afternoon, panelists. My name is Onyango Akumu Eugene, of registration number 2023-0830, a member of Class D, precisely Farm 16.
Okay, thank you and welcome, Mr. Onyango. Now, the first question to you. Assuming you are an advocate and you are representing a certain RTA, road traffic accident matter. So you appear in court and it's a hearing day, and your first witness is a medical doctor. So you're well aware that this medical doctor is the one who treated the victim, actually, one of the victims. And so your task now is to first examine the doctor in chief. So please proceed.
Okay, so in examining the medical doctor in the examination in chief stage, so these are the questions that I'll ask the doctor. So maybe you can repeat the facts, yeah, so that I can catch them well.
Can you hear me, Mr. Onyango?
Yes.
Okay.
Yes, I can.
I'll request that if you have a book, please don't peruse, because maybe when you appear before me or any panelist, you'll not be having. So if you're having a book, kindly don't peruse. Anyway, so you are tasked to conduct an examination in chief, and the witness is a medical doctor.
The witness is a medical doctor, so I'll ask the doctor. These are the questions that I'll ask the doctor. So, what's your name? I'll also ask the doctor, where do you work, so that I can be able to know the exact hospital the doctor is employed in or works in. I'll also ask the doctor about maybe if there is it's a case of medical negligence and the doctor maybe conducted a certain procedure on a patient, and the patient, as a result of the procedure, suffered some other damages, then I'll maybe ask the doctor, how did you conduct the procedure, so that can be able to understand the exact procedure that the doctor relied upon when undertaking the operation. I'll also ask the doctor about at what time maybe he conducted the procedure. So basically the questions I'll be asking the doctor will be aimed to corroborate the facts that were maybe in the doctor's report, maybe in the doctor's submission to court. So I'll try to ascertain what the doctor had alluded to as to what happened in that circumstance. Yeah, so basically those are the questions I'll ask the doctor.
Okay, thank you. Thank you so much, Mr. Nyango. So that was the first question. So now the second question to you is, what is the understanding of the word retainer?
So my understanding of the word retainer is contracting an advocate such that for a client to deal with an advocate, then there ought to be some sort of payment that has been made to the advocate so that when a matter arises, the advocate will represent the client. So you'll find when when an advocate is retained, he has basically been contracted to represent the client when a matter arises. So it's the first relationship between a client and another. Yes.
Okay. So ask you about the retainer. I understand that you know exactly what retainer is, and that is good. So now, imagining you're an advocate and you find a client who want to issue with a retainer. So what are some of the factors you are going to consider?
Okay, so the factors that I'm going to consider, basically as an advocate, these are the factors that I ought to consider before maybe taking the matter to court, or before maybe a client retains me. I'll consider the feasibility of the suit. Is the suit that the client wants to bring viable? Will it stand a chance in court? Will it? Yeah, I'll basically try to look at the feasibility of the suit. Another thing I'll look at is, when I take the matter, will I be conflicted? Maybe I'll try to ascertain whether there will be any conflict of interest that will arise when I take the matter. Then I'll also, those are the two considerations that I'll consider.
Okay, thank you. My other question is, do you understand, or have you ever heard a term lien in professional ethics? Lien.
Lien in professional ethics, I've heard it I haven't heard of it in professional ethics.
Okay, then. So I'll pull back that question. So maybe I'll ask you another question, and the question is: usually, as an advocate, we thrive in writing, and you hear, for example, there is an aphorism that once you're an advocate, you are supposed to dance as if no one is watching, but you're supposed to write as if the same is going to be read before the court. So now that tells us that there are very strict rules as to writing when it comes to advocacy. So what are some of the rules that you must consider for you to have an effective writing?
For me to have an effective writing, some of the rules that I'll consider are at the moment, I don't have a proper answer.
Okay, no problem. Maybe I'll ask you another question. You understand the meaning and the difference between passive and active voice?
Yes, I do.
What is usually the key difference between the two?
So the active voice, it focuses more on the action, and the passive voice focuses more on it's more of a reported speech. So an example I'll give of an active voice sentence will be: the advocate wrote on the book. So that will be active. But when it comes to passive voice, it will be: the book was written by the book was written on by an advocate. So between the two, the one that is mostly recommended when it comes to legal writing will be the active voice, because it sends the message clearly as compared to a passive voice. At first instance, a person will be able to comprehend what the message that is being conveyed in an active voice as compared to a passive voice. Yes.
Thank you. Thank you. Now, a follow-up question to your answer. The answer you just gave to me, you rightly so say that active voice is highly recommended in legal profession, or rather as an advocate. But then maybe a question to you. In your opinion, or what circumstances, in your opinion, do you think you will recommend or you'll be recommended to adopt a passive voice and not an active voice?
So under the circumstance in which you'll be recommended to write in a passive voice would be maybe when you are maybe, let's say an example would be when you are drafting, maybe when you are drafting your, I can't give a proper answer at the moment.
Okay, no problem. So maybe allow me to ask you the last question. And the last question is, have you interacted with a concept called the torrent system in the law of conveyancing?
Yes, I have.
Okay, would you just maybe briefly talk to us or to me about your understanding of the torrent system?
So the torrent system its origin can be traced to Australia, and basically the torrent system is used. It's basically the registration of title that are of land that are entered at the registry, because prior to that, it brought about it perfected the aspect of being able to conduct searches, such that when you register a title to land, then it will be easier to trace the land back to the owner. So I'd say that the torrent system has been codified by the Land Registration Act, and an institution that the proper institution that deals with registration of land, then it will be the land registrar, where the registrar is kept for land is kept. So the torrent system is basically the aspect of registration of land, title to land.
Okay, thank you so much. I think that has been our 10 minutes time with you. So kindly, Oduor, allow me to just give a review and the feedback to Bwana Onyango. Onyango, that was a good attempt. You did well. You are very confident in your answer. So just a quick review. The first, maybe I'll not follow the order of the questions I asked you, but I'll ensure at least to highlight all of them. So the first question was in respect to examination in chief, which you did really, really well. But then next time, kindly, when I ask you this, or when you meet Mwaniki, and Mwaniki gets to the witness, to the doc, and he asks you to maybe examine him in chief or cross-examine or re-examine, please don't tell him like these are the kinds of questions I'm going to. Of course, I understand the exercise was fashioned to actually attack such kinds of answers, but next time, just like ask direct. Act as if you are before the court and you are directly examining in chief. But the kinds of questions you asked, they were very proper, they were well conjured, and those were exact questions I would expect. The questions of 5 wives, you understand that, and 1 husband. Why, where, when, yeah, such kinds of questions. And you started well, because if you appear before Mwaniki and you hear some people, you'll be taught, or in practice, you'll hear someone tell the witness, please introduce yourself. Remember, that is a wrong question. You are right to say, what is your name? That is a W question. So in examination chief, you did well. Another question I asked you was a question with respect to retainer, and you defined to me what you well explained what a retainer is in form of an agreement issued by a client to the advocate. But I think where you didn't do well, I think you gave me one factor, the factor on the conflict of interest, but the rest you can maybe have a further look at it. One of the factors could be, for example, the issue of conflict of interest, say the scope of engagement, the amount of fees to be specified clearly. So those are some of the factors that you as an advocate must consider before taking up or committing to a retainer. Another question I asked was the question relating to rules of effective writing. I noted that, of course, in TSL, you hear a lot of stereotypes about forces. So people don't really focus on these other units. And that is why you understand that my focus has been on the other units, LWD and the other units. So the question on rules of effective writing is an LWD question. I expected you to maybe mention to me about the aspect of proper paragraphing, the aspect of completeness of your thoughts, your ideas, and what you're writing, the aspect of proper spelling, grammar, and what. So kindly just refer on your notes on the rules of effective writing. The second last question I asked was the question on passive voice. You distinguished them very well. In fact, the question followed up, you are not able to answer, but you had answered it in the first question when I asked you to distinguish, where we say that usually the how do you call it? Like it's usually the subject verb agreement, so that, or the subject verb object, that is the proper arrangement, that is the active voice. The object usually comes to end, and that is an active voice arrangement of a sentence. Passive voice takes subject comes. So the question was, in what circumstance would you recommend somebody to use passive voice? So the answer is passive voice focus is on the object. So where you want to lay emphasis on the object, you use passive voice. So I'll actually advise you to go read on some of the other circumstances. There are around 5. Some other 5 circumstances where you'll definitely use passive voice. The last question I asked you was, because you are not able to know the lien, maybe you can go look at it, what lien is in professional undertaking or professional ethics, but maybe you have not covered, and you'll have covered before you appear for your oral. Then the last question was in respect to tolerance system. You really started well, you have an understanding of the same, but ensure you're asked about the tolerance system. Please be keen to mention the principles. Some people categorize them as 4, some categorize them as 3. But the mirror principle, the curtain principle, the indemnity principle or the insurable principle, and the 4th one, some categorize them as the indefeasibility principle. So kindly be aware of that. And actually, to add yourself an advantage, the dinner management case is now well and everywhere discussed. You can also be able to bring such kinds of discussions, such kinds of cases in your discussion of such kinds of questions, because it was an open question. So you bring the statutes if you can, so that you give a chance to yourself to score higher marks, especially for the questions which you were passing. Thank you so much. That was our time, unless you have a question for me.
Thank you so much. I don't have a question at the moment.
Okay, thank you. Over to you, Bwana Daniel.
Thank you. It has been such a seamless session. Thank you so much for that. Thank you so much, Eugene. Okay, guys, so I'm looking for that lady. Again, we're back to that topic. So any lady who is ready? Any lady is ready? Okay, apart from Onyango, I think there's someone else. Onyango, kindly just maybe lower your hand. Please, if you're a lady in the yeah?
Daniel, we have Veronica.
We have Lorna Chege there.
Ah, okay. Hi, Lorna. Hi, Lorna. Hello. Hello.
Odur, it was Veronica.
Oh, Veronica. Hi, Veronica.
Hi, I'm tense already, but I'm ready.
It's fine. Don't worry. That's how you get through it. Okay, so you're ready?
Yeah, I'm ready to try.
Just don't think about everyone who's here. Just think about yourself. This is for you. It's not for anyone. So you can make those mistakes. We've allowed you. Don't worry about anything.
It's okay.
Okay. So Veronica, I know people. So many people have introduced themselves. I wouldn't want to go back to that. But maybe you can just explain this to me. Who is an advocate?
An advocate is a person who has been admitted to the bar and is in the role of the advocates and who represents people in court.
Okay, that's fine. So a friend of yours comes to your chambers and tells you that, they were watching CNN and they heard about this word mutiny. They've heard a lot about it this week and they'd like to understand the meaning of this word. So what's the meaning of the word mutiny? M-U-T-I-N-Y.
To be sincere, I don't know.
All right, that's fine. Have you been following the Russia-Ukraine war?
Not really, but I have an idea.
Okay, what's it about?
I'd say it's about the powers, the fight of power between the Russia and Ukraine. Yeah.
All right, Veronica. On to my next question. Do you know anything about the case of Republic versus Mwango?
Republic versus Mwango. No, I can't tell at the moment. I think I'm too much tensed.
It's okay, just calm down, Jennifer. It's it's just forget about everyone else. Just calm down. Calm down. Do you remember anything about Republic versus Mwango?
I don't know if I can remember.
Have you ever heard about that case?
Yeah, I've heard, but I can't really tell exactly.
Okay, what about Adan versus Republic?
I'm really tensed.
Okay. So then let me ask you other questions that probably will help you get back on your feet. So what are the different types of bail?
So the different types of bail, we have bail pending trial, bail pending appeal, bail for convicts, and bail for acquits.
What about anticipatory bail? Yes.
Yeah. Anticipatory bail is a bail that is someone seeks when they are in fear of being arrested, so they seek that bail.
Okay. So,
before they are being arrested.
Okay, that's correct. So what if someone asks you this question? What is the objective of giving bail? What's the object of the court deciding to give bail to a particular person? I mean, this person is accused. So why give them bail? What is the rationale behind it?
So the reason for giving a bail, first, it's a constitutional right under Article 49 of the Constitution. So it's a right of every accused person to be given bail. However, before giving the bail, the court has to consider some circumstances. And it is also assumed that since it's an accused being given the bail, they are yet to be tried to determine whether they are innocent or guilty. So there's no need of having them being confined before you get to know whether they're guilty or not.
Okay. Now, I was having a discussion with my friend Angelo, who propounds that we have bailable and unbailable offenses. Do you agree with that statement, that we have bailable and non-bailable offenses?
I agree, but it's debatable.
Okay. I'd like to hear your opinion.
Yes. So first, bail is a constitutional right. So bail being debatable in the sense that there are offenses that bail can be issued, and in other offenses, bail cannot be issued. So before the enactment of the 2010 Constitution, murder and treason offenses, generally capital offenses, were non-bailable, while the other offenses were bailable. But with the coming into place of the new Constitution and with the court's jurisprudence, it is now being held that it's the right of every accused person, no matter the kind of the offense they commit, it's their right to be given bail.
Okay, so we don't have bailable and unbailable offenses. All offenses are
At the
bailable,
moment,
right?
yeah.
Okay, thank you. Thank you so much for that. So to my next question, what is a police bail? If someone tells you that they've been given a police bail, what's a police bail?
Police bail is a type of bail that is being given by the police officer to the suspect while they are still in custody before they are being brought to court. So it happens particularly where the offense is, I would say, petty, and the police has power to issue that bail. So it's generally being given by the police officer.
All right, on to my next question. I think you told me that there are certain circumstances that are always considered before bail is given. Could you just tell me 5 of these circumstances?
So the first one is that before you issue a bail, what the court considers is the type of the offense. Another one is the sentence that is limited to the offense. The third one is whether the accused or the suspect is a flight risk. And then another one is whether there is a possibility of these accused interfering with the witnesses. Another one is the social background of the accused. So in the sense that where the accused comes from, is it possible for the court to secure the bail for this person? So even to some extent, the court goes to get a pre-bail report so that they can know whether this accused person can be given the bail.
Okay. Now, what's the general rule or the primary consideration in giving bail pending appeal? What's the primary consideration or the general rule? What must the court consider before giving bail pending appeal?
Mm-hmm. So first, generally, bail pending appeal is not a matter of right. So I would say the court considers what? Okay. I don't know. I'm forgetting.
All right. So my client David has been convicted by the court after pleading guilty. Again, my client David has been convicted by the court after pleading guilty. Now, David tells me that he would like to appeal not just the sentence, but the conviction. Is this possible?
It's not possible. You can only appeal to reduce the term of the sentence, but you cannot appeal to do away with the conviction.
So your appeal should and must only be on the sentence where you've pleaded guilty, correct?
Yes.
Okay. So where the subordinate court, this is my last question, where the subordinate court or the lower court has refused to give bail to a particular person, is it possible for this person to be given bail pending appeal?
Sorry, take it again.
Where the lower court or a subordinate court has refused to give the accused bail pending trial, is it possible for the higher court to give bail pending appeal where the convicted person now has decided to appeal? Is it possible?
First, bail pending appeal is not a matter of right. It's not a right that you must be given. And by the time the courts are of the opinion that they can't give you a bail, they have made the considerations already. So I don't think it's really possible here.
So you are saying you do not think, are you sure?
Okay, wait. I said being given that bail pending appeal is not a matter of right. So by the time the subordinate court is deciding whether to give this person bail or not, they have made some considerations on whether to give or not. So I don't think it's really possible for him to be given that bail by the higher court.
Okay. So, okay, what I'm asking is you don't think or you're sure? You're sure that it's not possible?
Yeah, because it's not a matter of right.
You're sure that it's not possible?
Yes.
All right. Thank you so much. Thank you so much, Veronica. You've actually done well, despite the fact that you're scared.
I'm so scared.
Yeah. Now, this is why we continue to encourage everyone to try. Veronica, the next time you volunteer yourself, it will be very different because you've already gone through this. So to everyone else who is listening, please allow yourself to be like Veronica in the first instance. And this will help you in the second instance. Because you've gone through it the first time, it will be easy to do it again. So please, please, please. Veronica, I think you answered my last question correctly. Where the lower court or the subordinate court has not given bail pending trial, the higher court will not give bail pending appeal. Okay?
Yes.
Yeah, that's the position. So that's correct. That's proper. I also asked you about bail pending appeal, the general or the primary consideration. The primary consideration is that the applicant must show overwhelming chances of the appeal succeeding for them to be given bail pending appeal. Okay, so maybe that's one thing that you can always remember. For you to get bail pending appeal, you must show overwhelming chances of the appeal succeeding. That's the general rule. Of course, we also have, secondary considerations like medical condition, the sentence imposed, and every other thing. So the primary consideration is that you must show overwhelming chances of the appeal succeeding. I hope that's okay now and that's clear to you. My question on police bail, you got that correctly. I don't think I'd have questions about that. Factors to be considered by the court when giving bail, yes, I think you got some correctly. But again, maybe this you can always have them in mind. Likelihood of appearance in court, likelihood of interference with investigations, likelihood of interference with witnesses, the nature of the offense, as you stated correctly, likelihood of commission of more offenses, as you stated correctly, then the safety or security of the accused, and even the public. That's okay. Then I asked you about whether it's possible to appeal on the conviction after pleading guilty. I think you said that you don't think it's possible. Now, the reason why I kept asking you don't think or you know is because you said you don't think, meaning it's either way. So the answer is it's not possible. You can only appeal on the sentence. You cannot appeal on the conviction where you pleaded guilty before that particular conviction. Let me just look for that particular provision of the CPC. I'll get it and share it with you guys in no time. If someone knows it, you can just post it in the group. Then, it's section 348, by the way, I just got it. Section 348 and 379 of the CPC. No appeal is allowed in the case of an accused person who has pleaded guilty and has been convicted on that plea, except as to the extent or legality of his sentence. Sometimes lecturers ask these questions. Please just ensure that you know it. Where you have pleaded guilty, no appeal is allowed unless it is embedded on the legality of the sentence, not on the conviction. Of course, we also know about Adan versus Republic. So where that is the case, you pleaded guilty, but there was some duress, then yes, you can always use Republic versus Ndende and other cases to actually quash that plea. Then, Veronica, I also asked you about Republic versus Mwango. This is homework that I'm giving you. Just try, Veronica, and ensure that by tomorrow you know about these cases. These two cases are always asked. These two cases are the easiest cases. If you do criminal litigation and come out with nothing, at least you should know about those two cases: Republic versus Mwango and Adan versus Republic. Adan versus Republic is on the procedure to be followed when recording a plea of guilty. The procedure to be followed when recording a plea of guilty, Adan versus Republic. Now, Republic versus Mwango is on ID parades. Republic versus Mwango is on ID parades. And what the case says is that where the victim or the witness that we have in place knows the accused person, where they know each other, probably they've been living together, probably they are friends, they know each other's faces, they know how they look, then there's no need to have ID parade. There is no need to have ID parade in that particular instance. Why? That will be a case of recognition. Okay. All right. Yes, it will be a case of recognition and not, like it will be a case where you already know this person, so that there's no need of us having, going through that process again. I already know you. It's like, let's say I know Angelo, so I know how he looks, I know his color. Then we are having an ID parade so that I'm able to identify Angelo. That will be a case of recognition and not identification. I already know him. There's no need for us to have an ID parade. Is that okay?
Yeah.
Yeah. So those two cases, please just do your homework, and I believe that you'll be okay, Veronica. But you've answered the questions nicely. Even though you are scared, you've done well. If I was on that panel, could have given you a 17 or an 18. I think you've done yeah. So just keep volunteering yourself, and you'll even do better, Veronica.
Thank you.
Okay, thank you. So guys, maybe we can have another lady. Yes, Angelo, maybe you can get yourself a lady.
Okay. Okay, I will get myself a lady. May I have a lady, please? I know Lual John, you will come next. I have been asked to get for myself a lady. Please, may I have a lady, please? Have you seen any lady, Daniel? I have no lady yet.
can
By
see
the way,
Lily.
nakwanga mtall, dark, and handsome. Usitoroke.
There's one with the name that starts with L. Check.
Any lady for Angelo? Any lady for Angelo? Guys, please don't let him down. Any lady?
Don't let
Let's
me
do
down.
this quickly. Let's do
That
this quickly,
lady
guys.
called Lona Chege.
Oh,
Skolu?
Lona. Also. Okay, just
No, Lona Chege. Public demand.
Eh. Okay. Lona Chege, this is the second time your names are being called out. Please unmute. Ayeko, why are you proposing Lona? I haven't seen her hand.
Yeah, she's scared, but I know she can do well. Let her go so that she can encourage men here.
Lona, I will ask you simple questions, please. We have spent 2 minutes asking for ladies.
Angela, if there's no lady, I think we can just go with the man who is present.
I will go with Ayeko. Ayeko, you are calling people out. Ayeko, please unmute.
Okay, I have unmuted. I'm ready.
Very well, very well. So, Honorable Ayeko, please differentiate for me the following.
Yes.
Give interviewers.
You are not allowed. You are not allowed me to even introduce myself, or I'm known.
You will introduce yourself next Saturday. Meanwhile,
already have my 7 marks. Thank you. Let me proceed.
Yes, please. Mr. Ayeko, please differentiate between give interviewers and donatio mortis causa.
Wow, thank you so much. I was not prepared for this day, but because people are not volunteering, I have to go. So gift intervivals are those gifts that are given by a person in the course of their, before they pass on. And gift in contemplation of death. There are those gifts that they are given. They're given in contemplation when someone is on their deathbed, or probably expecting an unfortunate scenario of going back to the Mecca, and so they want to gift out some of their assets before they pass on.
Okay, thank you. Are you aware of any section of the law that governs those two?
Yeah, yes, I am aware of the LSA Act in general, of the LSA Act in general, but I don't remember the specific section that governs gift intervivals and gifts in contemplation of death.
Okay, I am not even sure. What is LSA?
LSA is the Law of Succession Act, and it's a statute that governs both probate and administrative lives of the deceased.
Okay, thank you. So, Bwana Ayeko, recently I came across some article that was talking about minimum composition of the Court of Appeal. I am not a lead researcher. I am a CLE finalist. But can you please assist me? What is the minimum composition of the Court of Appeal judges?
Court of Appeal, first of all, allow me to bring you to up to speed about the Court of Appeal. Court of Appeal is among the 3 superior courts. Before the enactment of the new constitution, it was our apex court. But after the promulgation of the constitution on 27th of August 2010, it became our second highest court in the land, and it has several judges, but the minimum quorum, if I'm not wrong, is 5 for any case.
Is that the position?
Okay, I would say that is the position. I know it has a maximum of 30 judges as at now, but for purpose of hearing a case, it must have a minimum of 5 judges.
Okay, thank you. Let me proceed because of time. Let's say in a few words or so, describe the trial process in criminal litigation. Just go step by step, just mention, no explanation. Where do we begin and where do we end?
Wow. I can say, I'll give it a shot. My understanding is that in criminal cases are basically offenses that are not civil, but they affect the public in general.
I'm asking about the trial process.
Yes, I'm going there. But then okay, let me go there straight to the point. I think it has 4 stages, and the 4 stages include the opening of proceedings, where we have a pre-trial conference where matters of how the issues will be addressed in court are done. And then we have examination of evidence, where the evidence that has been brought to the court is put to test. Remember, they also have a high standard of proof, burden of proof, and so they have, and the fact that it's an adversarial system, the evidence must be looked at keenly. The 4th stage, I would say, is found in the Evidence Act, where there is issues of questioning by both parties, just to understand how witnesses are going to play their role in ensuring that the evidence adduced is credible or meets certain submissions or certain submission as per the cases. Then lastly, it has, just like any other case, it has the closing arguments, where both parties provide their closing arguments to allow the judges to make a decision. Thank you.
Okay, thank you very much. Please distinguish for me between judgment and sentencing.
Thank you. Judgment is basically the ultimate process of a case, the ultimate determination of a case, where a judgment is given, an order is given, and this order is form of a decree, which is extracted for action, while sentencing is now the final process, where now a decision is made on how the offender will be punished. And in this case, maybe what I would say that it's the punishment is given in form of sentencing, like how many years the offender is going to spend in jail, etc., etc.
Okay, thank you. We are now approaching the end of our questioning. Further, you have talked about extract. So now let's go where maybe something might be extracted. So differentiate for me what a decree is and what an order is. What is the difference between the two?
Okay, I would say that a decree is to a judgment, and an order is to a ruling. And in judgment, I mean the final decision. In a ruling is on a matter within the case, where maybe either party has sought clarification on an issue, and so the court issues an order so that the process can continue. While a decree is extracted from a judgment, whose case has been concluded. Thank you.
Okay, thank you very many. So maybe to conclude further, please discuss 4 instances when it is permissible to use passive voice instead of active voice as an exception to the general rule.
Wow.
Have you learned active voice, passive voice?
No, we haven't learned substantively, but I can just give it a shot. But we haven't delved into the issue deeply.
Okay, you haven't dealt with the issue, so I will not allow you to proceed, but know that you will be expected to answer the same next time. But for now, let me ask you my last question. Okay?
Yes, thank you.
Very well. So my last question is still on legal writing and drafting. Please give me at least 5 basic rules of plain English.
5 basic rules of plain English. I would say one is the question of the 5. I think the question of the 5 W's. The question of 5 W's in writing, where you are supposed to make sure that you capture well without ambiguity the question of who, the question of what, the question of where, the question of when, and the question of why in any legal case. And perhaps additionally, you must also be in a position to explain in those circumstances all the legal issues that are happening around the 5 W's.
Okay. Sawa. So what is actually being done to promote plain English in Kenya?
What is being done to promote plain English?
Yes.
I can say, yes, in 30 seconds, I can say plain English is being taught at the advocates training programs across the country. And this is basically, especially for those lawyers who are training to be advocates, because we have seen through client and stakeholder feedback that the clients that lawyers have, they're not able to understand the legalese by virtue of the letters and communication that they receive from the lawyers. So most lawyers most advocates are advised to use plain English so that they can serve their clients well, and then they can also have a common understanding on legal issues that a common man may not understand if they use the legalese.
You have just said the common man. Is that the position, sir?
Yeah, if you look at the way the Constitution is framed.
I have no issue with your explanation, but I have an issue with the word common man.
Okay. Thank you so much. I think common man has multiple interpretation. To you, it would mean a different thing, but maybe as at now, the common man is not satisfied with the language. Hence, the programs to ensure that there is a far much use of the plain English in communication in general in the Republic.
Now, in my conclusion, then you will need to. This is not a question, but you also need to study what is known as gender neutral language. Okay, it is also part of your program. Sawa.
Yes, thank you so much.
Mr. Odur, if you may allow me, I can proceed to give my feedback to Mr. Ayeko.
Of course, sir.
All right. Mr. Ayeko, you will need to look at this one. I believe my learned colleague, Mr. Ooko, on the aspect of circumstances under which passive voice is allowed. They are 5. So please look them up You said that you have not reached active voice and passive voice. So please, that is it. And then on the aspect of the basic rules of plain English, number one, it is use of short sentences. Okay. So generally, I don't know if you have reached there yet, but your sentence should have 25 words or less. That is better. Okay. Then number two, it is use correct grammar and punctuations. Okay.
Yes.
Then number three is something known as use everyday English. Just simple. Don't complicate things here in after, here into for, here in that all. Okay. Then use simple structures, use first and second person, arrange words with care. Okay. And with the aspect of what is being done to promote plain English, you are actually very correct. And that is why you are now starting LWD. So, but you realize that court orders, simple English. Standard forms, regulations, simple English. If you look at the laws or if you look at our Civil Procedure Act and Rules 2010, you will see that they are being drafted or they have been drafted in what? In plain English. Okay. Then if I go to the other aspect, give intervivos or give interviews where you took your first water and donatio mortis causa. So the give interviews means the transfer of property that becomes operationalized during the lifetime of the donor. Okay. Whereas on the other hand, donatio mortis causa, it is made in contemplation of death, the ways that you actually the way that you stated it, and always passes to the donee upon, that is after the death of the donor. Okay. And it resembles give inter vivos in that it takes effect upon the delivery of the property, but it takes effect when the donor dies. All right. Then when I was talking about the composition of the Court of Appeal, so the court is properly constituted by having a minimum of 12 judges. So the Court of Appeal will never have like 11 judges. So if it is as 11, then the court has not been properly constituted. It is the same that we must have a certain minimum number of judges of the High Court, a certain minimum number of judges of the Supreme Court. So for Supreme Court, I believe it is 5. That is, unless if I am mistaken, but that court cannot go below 5 judges. The same Court of Appeal cannot go below 12 judges. So composition, it means that what is the minimum number of judges that should be in that particular court. Okay. And when I was telling you to, in one word or so, to describe the trial process, the first one, it is start with the complaint, whereby my good friend Donna, okay, she's not my good friend, I don't know her, but yes, I have known her here, will go to the police station and file her complaint. Okay. Thereafter, investigations will be conducted and arrest will be made. Arrest now is the second step. Thereafter, charges will be drawn. Thereafter, plea will be taken. Then after the plea, trial will begin. After the trial, we know there are 2 steps there whereby the prosecution will begin their case, then the defense will comment their case. Then now the second last one is the judgment, and then the last one is sentencing. Okay. Complaint, arrest, charges, pleas, trial, judgment, sentencing, in that particular order. Okay. So judgment and sentencing, judgment means adjudication by the court in that a defendant or an accused person is guilty or not. So it is that particular finding of the court. Whereas on the other part, sentencing is actually a procedure under which a particular court of law or competent jurisdiction makes an order on the specific penalty to be made on an accused person. Okay, so it is a procedure. And if you look at the Moratetu case, it has actually been stated that sentencing is part of fair trial, such that when judge is being ordered by a statute that death penalty is mandatory, so it takes away that aspect of fair trial. So sentencing on its own is a procedure. All right. Then finally, it is on the aspect of a decree or an order. I like how you tackle it. You knew your goal, so even if you went around it, that was fine. So decree is extracted from a judgment, whereas an order is extracted from an interim application. So that is it on my side, Mr. Ayeko, unless if you have a burning question.
Yeah, okay. No. I think you've answered my questions, my worries. I'll go back to the drawing board and come back a better person. Thank you.
Very well. You did really well, but I'm not going to give you your marks. But you did well.
I'm not getting 18.
All right, Daniel, please take it away.
Thank you, Angelo. Good job, Ayeko. I think that was really, really good. All right, we move on to the next person. Oko Hesbon, take it away, man.
Done. A volunteer already. I can see someone.
Yes, Esbon, you have Lual John. And we will have the next person after Lual John.
Okay,
So
Lual.
we have
Guys, I think Hesbon. I think there's
Yes.
someone who has been raising their hand for quite a long time. Angelo, I think you're able to see him before.
Lual.
Before
Lual?
Ayeko. No, apart from Lual,
Okay.
there's someone else, or?
There is Anyona, and then there is and Lona now has found her voice. She has raised her hand.
Okay, let me proceed with the Lona.
Yeah. Then I believe Lual will come after Lona. Then Anyona next.
Yeah.
Good evening, Lona.
Good evening. I think it's a different Lona. I'm not the one that the guy was talking about.
No problem. I think it's in order we can proceed. Is it your first time, or maybe you have volunteered before?
It's my first time.
Okay, now, Lona, I'll give you a chance to introduce yourself, assuming that you appear before us in the morning.
Good morning, panelists. My name is Lona Maryville Nyabonye, a member of Class C, Farm 9, admission number 2023-1155. Thank you for having me.
Okay, thank you so much, Lona. Now, I will have some few questions for you. And the first one is very direct. The first question is, which document and the underpinning law for the same will you accompany the plaintiff with?
I would accompany a plaintiff with a verifying affidavit, a witness statement, a list of documents, and a list of witnesses. For the law, I think I'd have to check.
Okay, thank you. Another question for you is, you understand that in an office, there's usually what we call filing system. So maybe you would just mention to me the different types of filing system, in a law firm.
So I know the different filing systems that exist are vertical filing system, horizontal filing system. Those are the two that I currently remember.
Okay, thank you. So now, you have started your own law firm, and you really have quite a number of files in your office, and whatever you wish is just to achieve a good system of filing. So what do you think will be the characteristics of the fact or characteristics rather of a filing system that will be considered to be good?
I think it depends with the it depends with how you divide your work. So the amount of documents that you have in your law firm, accessibility of the file. So those are the ones I know. Then yes, those are the ones I know.
Thank you. So I have another question. And I request you to just assist me in understanding these three words or phrases. The first one is judgment. The second one is judgment in default. And the third one is summary judgment. What do you think they are in your understanding?
So in my understanding, can I go in any order or according to how you said?
Just any order.
Okay. So a judgment is mainly in criminal law, where the presiding judge determines whether an accused person is guilty or not. Then a summary judgment summary judgment and judgment in default are mainly in civil matters. So a summary judgment is a judgment that is given by the court once the accused, once the plaintiff has served the defendant and the defendant has entered appearance, but they have not yet provided a defense. Then judgment in default is a judgment that is given when a defendant fails to appear, to give appearance, yes, to enter appearance.
Okay, thank you. Maybe let me have a follow-up question to the same. You did mention that in your position, or your understanding is that judgment is usually in criminal litigation, that the court gives a final decision and someone is guilty or someone is not guilty, so that is judgment. So maybe have a question to you, maybe assist me, try to understand this, that you are an advocate representing a plaintiff. Then you have another advocate on record who is representing the defendant. So you filed a complaint, the other one responded accordingly. You proceeded to file submissions. Because there was hearing, then you filed your submission. Then after that, the court went back to now determine the key issues and just render the decision on what your issues, the issues you are claiming in that plaint. So what would you call that decision, that the final decision that the court gives in that matter? You are representing the plaintiff. So what would you call that decision?
Okay, I think I fumbled there. So yes, I think it's also a judgment.
Okay, then. So would you maybe just try to tell me, you spoke about the summary judgment and the default or judgment in default, or default judgment. So usually when you talk about the summary judgment, there are some call them 4 corners of summary judgment, but I want to pin it down to just 3. Maybe you can assist me in understanding what are these 3 key things that must be present for you to go for a summary judgment.
I think I would have to go and read on that.
Okay, no problem. Another question I have for you is that maybe do you understand what an agency is?
Yes, I do.
Okay, what is maybe the meaning of or your understanding of agency?
Agency is a relationship which is created by an agent and a principal to conduct certain business agreements.
Okay, so now you have, I think you have well defined what agency is. Now, a follow-up question I have for you is, at what circumstance do you think an agency relationship can be terminated?
So I think, an agency relationship can be terminated in two ways. So by the act of parties, where the parties decide to go their own ways, and by operation of law. So by operation of law is either through performance of the contract, the expiry of the period that had been fixed for agency, and then death of either of the two parties. Those are some of them.
Okay, thank you. So the second last question I have for you, Lorna, is one. You have been instructed by a certain family. The family tells you that their former advocate unfortunately passed away, and their former advocate had assisted the family in obtaining a limited grant. So that limited grant was it was grant pendente lite. No, let's not go with that. Let me go with ad colligenda bona. So the former advocate had assisted the family in obtaining a limited grant ad colligenda bona. So now, unfortunately, this advocate actually passed away, and the ad colligenda bona was meant to last for 6 months. So maybe before I proceed, what is your understanding of this type of limited grant? Before maybe we can proceed, what is your understanding of this grant I'm mentioning, ad colligenda bona?
It is found under Section 67 of the Law Succession Act, and it is a grant which establishes an estate which constitutes of perishable goods such as crops. Yes.
Okay, good. So now, so this advocate who actually passed away assisted this family in obtaining the limited grant, which is now the ad colligenda bona that you well contextualized it. So now, and I said that this grant was meant to lapse or rather expire after 6 months. Unfortunately, the work of collecting the perishable goods has not really elapsed or extinguished, or rather, there are some other perishable goods to be collected. And at the same time now, the grant has come to an end, like 6 months time has ended. What grant, or rather, which advice would you give the family?
I would ask the family to get a cessante grant, which extends the grant that was earlier on granted. Yes.
Okay, good. So the last question to you then is, you understand the concept or rather the principle that is well celebrated in the commercial law classes in campus? I know you went through university. There's a doctrine, call it so, called nemo dat quod non habet. You know it?
Yes, I do.
Okay. So now, I don't want you to tell me what it is, but the question I want to ask you is, what are some of the exemptions to that rule, nemo dat quod non habet?
I would say where there was misrepresentation to the seller and where the person conducting the sale exceeded their authority.
Oh, you're done with that?
Yes, those are the two that I remember.
Okay. Oh, I noted that because you've used my, you had 1 minute on this one. You've utilized 30 seconds. Maybe I'll ask you, what is your understanding of section 6 and 7 of the Evidence Act?
I am not conversant with that, but I think I will go back and check on it.
Okay, thank you. That was it. Bwana Oduor, if you may allow me to give the review.
Of course.
Okay, thank you. So, Lorna, you've really done so well. I am really impressed. Other than just some few questions that you maybe were not able to answer, you did so well all the questions that you made an attempt. So on the questions of the first question of the question of which document to accompany the plaint, that you did so well. You were able to establish that a plaint is the pleading, so you accompany it with the verifying affidavit, and those are the statements, witness statements, list of documents, and among others. But you remember there was one question on the same. I asked you about the documents to accompany and the underpinning, the legal underpinning to the same. So please, I'll invite you to go read Order 4 and Order 3, specifically Rule 2, to understand which documents you have to accompany the pleading. But you were able to identify all the documents. That was really good. Then on the filing system, you were able to establish the categories of filing, characteristics of good filing system. You really tried, but you see, if you ask about characteristics of a good filing system, talk about the aspect of it's easier to retrieve documents. The aspect of safety, reliability, durability, all those aspects. Good filing system, like characteristics that make filing system effective. That is what really I wanted to get from you, but I think you did well on the question. Now, on the question of what judgment in default and summary judgment, I noticed that when you started, at first I think you didn't get it clear, maybe until I made a follow-up call on what judgment is. You need to maybe have a further reading on the same. Judgment can appear both in civil and in criminal affairs, as you had said. Then default judgment and summary judgment, I think that one you answered well, other than the fact that maybe the question of what are the four corners of summary judgment. You'll appear before Mongare, and Mongare will ask you that what are the four corners of summary judgment. So what are some of the factors that must be, or the features that must be present for you to proceed for a summary judgment? And the first one is that the plaint must be a recognized claim. Then the claim must be a claim. It's called a claim for an amount that you know. Actually, it's called if the claim. Lorna, I'm still having a conversation with you. Sorry. If a claim is of an amount that you know, how would you call that?
A liquidated claim.
Correct. So a liquidated claim, like you know exact amount, and then also, like for example, you have filed a suit. Somebody has entered appearance, but a defense has not been filed. You see, so you're supposed to understand those are some of the factors that must be present before you proceed with the summary judgment. Then on default judgment, you rightly got it that in default judgment somebody has failed to enter appearance, and that is why it is called default judgment. And then on default judgment, I'll invite you to have further reading, because if you meet someone like Tuge or even Mongare, she'll want to challenge you, your understanding on the process or the procedure of default judgment for individuals and for the government. So it's important to go distinguish between the two. What is the procedure? Will you request for judgment for the state, and or rather will you apply for default judgment for the state? Those two words, get to understand them. Then another question I asked you was the question on agency, in which you, I think you were very clear on that. You scored all the marks. For example, if there's an agreement between the parties, you can terminate. If by way of operation of the law, discharge of duties, or where, for example, the agency dies, you see, the agency relationship will just have to terminate. Then the second last question I asked you was the question I tried to challenge you with the SATE grant. And I noted that, wow, you really got it so right. That the SATE grant is a grant where it's a limited grant you apply so that you continue that which you could not finish with the other limited grant that just extinguished. So you got it very right. Then, and actually I tried to challenge you by saying the advocate died, so that, you know, when someone just here died, you start thinking of the bonus non-administrative. So that is why I brought the words like dying, mini, but I think you're very, you're very ready for this. Then the second last question I asked you was NEMODAT. So when I noted that you, in fact, knew this, I tried to destabilize you with a question of Section 6 and 7 of the Evidence Act. Let that not scare you, but you will meet someone else who may ask you, especially if someone like Dr. Owino. Just know Section 6 and 7. There are some sections or provisions of law, just know Article 49, Article 50, Article 24, 25, Section 6 and 7 of the Evidence Act. Those are provisions of law that you must really, or they must be in your fingertips. So Section 6 and 7, when you hear it, just know it is res gestae or res gestae. Then the question on NEMODAT, there are 8 exemptions to NEMODAT. Please go read about NEMODAT and also know the exemption. But exemption can be, for example, if it's a resale by the seller who is in possession, if it is seller by can be sold by the agent of a merchant. For example, if you go to Gikomba, you meet those. I don't know if you go, but if you ever gone there, you meet those agents with holding some cloth. They want to pass the title to you, and they are not actually the owners. You see, that is an exemption to the rule, because otherwise the rules say only the owner can pass the title. So such kinds of exemptions are what will be asked about, or what I was testing you about. So generally, you did so well, really did so well. Just go brush on the few points which I've highlighted, and you will do well.
All right. Thank you so much, Hezbon, and good work, Lorna. Okay, so Angela, you wanted us to go with John?
Yes.
I don't know if he's still available. John, how are you?
Lual, John, you can proceed and unmute.
Yes. Sorry. I'm late today because my phone has been disturbing me, so it hangs, and I've been missed. I was supposed to be the first person to speak, as usual.
Wow, nice. How are you doing?
I'm doing good. How are you?
I'm also well, John.
Yeah.
John, do you support any team that plays football?
Automatically, that is Arsenal, the best team ever.
So you and Angela must be friends.
Yeah, but Angelo come after me. I was the one introduced him to the to Arsenal Football Club.
So chairman. Okay, that's fine. So I'll just ask you a few questions, then we'll be done before you know it.
Okay, welcome.
All right. So, John, what's a professional undertaking? If, let's say, I was dealing with you as an advocate and I ask you for a professional undertaking, what would I be asking for? What is a professional undertaking?
Thank you for this question. Professional undertaking is equivocal intent for someone to take the responsibility of a certain act. It is an agreement between an advocate and advocate to carry on behalf of the parties.
Okay, that's fine. So what are just give me five principles. What are the 5 principles of a professional undertaking? I'm told it's as good as money. So what makes it as good as money? What are the principles?
Thank you. The first principle is that it must be an agreement. It must be unequivocal, so that it gives an obligation for each of everyone to perform his part as an agreement to do that obligation. And the second one is to make it as a contract, so that once the other party perform his duties, then the other one should also to comply, and then it can be a risk when you have not performed your duties as required by the principle of the undertaking. So it's like when you give me an undertaking, do you mean that I have to fulfill my obligation, and if I will not do that obligation, it will amount to misconduct, and to bring penalties on my side. That's what I can say about undertaking principle.
Okay, thank you. So my good friend Hesbon wants to sell his property to, let's say, person X, and Hesbon doesn't want to discuss this with the wife, yet the property that Hesbon is intending to sell is their matrimonial home. So, John, maybe would you just explain to me whether it's possible for Hesbon to transfer this property to this person X without engaging and involving the wife?
Okay, thank you for this question. According to the law of the conveyancing principle, so the property will not be proper transfer, because for the transferring of the property to the other party, there must be document to be given or to be filled in order for the property to pass to the other party, and one of them is spousal concern. So spousal concern, meaning that if it is a matrimonial property, the spousal consent must be given as one of the required documents, so that the advocate who is representing that agreement of the property in that matter must know that the concern of the other partner or the other say the wife, of the other spouse is given. So meaning that it will not be a proper transfer of the property. So the consent must be given.
All right, John, thank you. Now, there's a friend of mine who keeps using these words loosely. That is latent defect and patent defect. Would you like to maybe explain to me the difference between the two? The difference between latent defect and patent defect?
Yeah, actually, this Latin word, I've just come across them, but let me try. Latent defect and which other one? Sorry, you say latent defect, and which one again?
Patent and latent defect.
Patent and latent.
Correct.
Okay. Latent defect. This is I'm humbly requesting if you can let me go and do my research about these Latin terms.
No problem at all. So we'll move forward to the next question. So I'm told, or rather informed by my friend, advocate to be, that's Angelo, that before I engage myself in any conveyancing transaction, I ought to have conducted my due diligence. That before I engage in any conveyancing transaction, I ought to have conducted my due diligence. Now, I'm struggling to understand this term due diligence. What does Angelo mean when he tells me that I have to conduct my due diligence?
Okay, thank you for this question. As I'm a conveyancing advocate, so due diligence means that you have to do in a proper manner, which can make a legal transfer or a legal contract based on the property that you are dealing, which means you have to make all the steps possible without any ignorance of whatever required in the transfer of the document or in the selling agreement of the property, especially for land.
So what am I supposed to do exactly? What am I supposed to do?
Okay. Mean that what you're supposed to do, when you're of agreement to a certain property, you must know the step that should be followed when you are doing that matter. To be in due diligence, you must first of all make a first step of entering into the agreement, and then you must do the free contract stage, then the search, like you have to do the searches, and these searches, you have 3 searches which you're supposed to follow, like official search, postal search, and personal search. So that you know exactly what is the property about, and then you come to until you read the completion of the contract, completion contract. That's what is meant by due diligence. You follow all the steps and the procedures.
All right, John. I'm also told that an official search is preferred to a personal search. Why so?
Okay, thank you. Official search is also referred to personal search. This is because once you apply for official search, you just seek a permission from the registrar, the land registrar, in order to give you a permission to go and do the search. And it doesn't mean that official registrar is the one involved or is the one to go to search that property. It means that you just take the permission from that registrar to give you a go ahead and do your search. So you will be given that document to go and do that search. That's why it is called that is why it is related to personal search.
All right, John. I was asking if is there a difference between an official search and a personal search, and what's the benefit of conducting one as compared to another? Could there be a difference?
Yeah, there is a difference because official search is that's what I was trying to explain. In official search, you do it by way of getting the detail from the registrar about that property. But personal search, this whereby you can just go and do the search by yourself or through the advocate, which is that representing you in the sale agreement. So that is like the personal search.
Very well. That is well explained. The benefit. The benefit is because
the benefit. Yeah. Okay, the benefit of let me start from personal search. Personal search, the benefit of personal search is that it can't let you know exactly what is the property about. So, like once I go to a certain place and see if it is about the land or the house, I should know which area or which place is that property is located, and what might be the issue raised if I buy this property, or if it is or if there is anyone who is having any issue about that property. And so that is the benefit of it. You have to go and look exactly what is the property about, and for official search, you have all the detail. You get all the detail about the property through the registrar, because the title of the property, and if there are charges or whatever, if there is anybody who is having interest in that property, so you must know. That's the benefit of official search.
Okay, John.
Or if it is owned by two or one person. So.
Right. Okay. Thank you for the attempt. I think it is a good attempt, and what I can say is just keep moving, just keep pushing, and it gets better. It gets better with time. Just keep brushing up. But John, this is a secret. The more you read, the better. The more you read, the better. So just try your best to spend more time studying, and it will even be easier. But yes, you've done well. You have an idea about the questions that I was asking you about, just that I need to make a few clarifications. Now, when I asked about the benefit of an official search as compared to a personal search, is because when you talk about an official search, then once you've conducted an official search and the government or the registrar has informed you of the status of the land, then you are protected. You have indemnity from the government. That is the main and the major benefit. That if things go wrong, then the insurance policy, as per the torrent system of law, kicks in. Meaning, as espoused in Gitwan versus Taj Mahal and others, you will be paid for any losses that you make in the event that you've done an official search, and whatever happens is not consistent with the official search. The government tells you that this property actually belongs to person X. Then at the end of the day, you get to realize that property belongs to person Y, and you make losses at the end of the day. So that's the importance of the benefit of conducting official search as compared to a personal search. If you conduct a personal search, then you do not enjoy that right of indemnity. So yeah, I think that is very important. But yes, I do realize that you know the difference between the two, and your answers in relation to the difference was correct and proper. Now, I also asked about professional undertaking. Yes, your definition was okay. I have no problem with it. But just to clarify it and to make it simpler, just say that a professional undertaking is an intention or a promise made by one advocate to another. Full stop. You don't even have to say much. An intention or promise made by one advocate to another. That if I promise you, John, that within 60 days, I'm going to send the money to your account, I ought to send the money to your account. So it's an intention or promise made by one advocate to another. Full. You don't have to say much. Then the principles of a professional undertaking, they include if the undertaking has been given by an advocate in their own capacity, then they remain personally liable. 2, it's only the recipient of a personal undertaking that can complain of its breach. It can't be that I gave an undertaking to you, John, then someone else is coming to court to complain of its breach. Then an undertaking, then an advocate cannot assign the burden of an undertaking without the express approval of the recipient. I cannot assign the burden of that undertaking to someone else, and I'm the one who gave it, without the express approval of the person who I've given it to. 4, ambiguous undertakings are generally construed in favor of the recipient. This comes or stems from the principle of contra preferentum rule. Ambiguous undertakings are generally construed in favor of the recipient. 5, an undertaking will still be binding even if it is to do something outside the control of the advocate. And just to give you the 6th one as an addition, an advocate cannot avoid liability on an undertaking by pleading that to honor it would be a breach of their duty or of the duty owed to the client. Of course, not the duty owed to the court, but that to honor it would be a breach of the duty that they owe to their client. I asked about due diligence, and I think what I was looking for specifically was the process. When I talk about due diligence, what do I mean? What does it entail? So you talked about searches, and that's proper. That's okay. That's the first step. You have to conduct searches, and even you explained these searches. You said we have an official search, we have a personal search, we have historical search. That's okay. But you ought to have gone forward and also talked about pre-contact inquiries. I think you touched on it a little bit, but you didn't really delve into it as much as maybe you are supposed to. But yes, at least you have an idea about it, which is a plus. But apart from pre-contract inquiries, we also have requisitions. Apart from requisitions, we also have proof of title. John, if there's something you can die with, then you can die with those 4. But in due diligence, we have searches, which are 3, which you talked about: official, personal, and historical. Then we also have pre-contract inquiries. Then we also have requisition. Then we also have proof of title. So when someone asks you about due diligence, you need to explain those 4 things and what they mean. Now, to know what they mean, you just get into the notes, and that will be very, very, very easy. Now, I asked about patent defects and latent defects. These are not Latin terms, they are English terms. So just to explain, patent defects are defects that you are able to recognize if you do a search. These are defects that can be recognized by any person who has decided to do their due diligence. But latent defects are defects that you are not able to recognize even after doing your search or after doing your due diligence. For example, a house is built in a place where, when the rainy season comes, then the house floods. Or when the rainy season comes, the pipes flood, or something happens. If I'm buying this house in a sunny season, not the rainy season. It could be possible that I do not know about the fact that when the rainy seasons come, I need to be ready for floods. I need to be ready, for the fact that I won't have water because of a few issues with the pipes here and there. The plumbing is a problem during the rainy season. I can't know this if I'm buying the house during the sunny season. So unless I'm informed of this by the person who is selling this property to me, the vendor, then there would be a problem. So where we have latent defects which were not explained by the vendor, then the vendor will be liable at the end of the day. But where we have patent defects that you ought to have known, for example, the physical condition of the land, the owner of the land, etc., then where we are having those issues, then you will be liable. For example, when it comes to physical state of the land, once you have signed the contract, then you take the land as it is. John, do you have any question for me?
Yeah. Oh, yeah. So, okay. It is not in our exams, but you say before when you, I think, who say it is Oko about if there will be no appeal when the accused has been guilty, has been proved guilty, or the judgment has been entered. So my question is, if you cannot apply for appeal, is it also applicable to the plea bargaining, or what is the position? Like if the accused plead guilty and the judgment has been entered, is it not possible also to that's my question.
Is it possible? Is it not possible to do what? The last part of your question?
For plea bargaining.
Or plea bargaining. So where you have entered a plea of guilt, then we are past you entering into a plea bargaining. We are way past that. We've already entered a conviction, and we're moving on to the next step. So if plea bargaining was to happen, then this would happen before maybe you've entered this plea of guilt. Because once you enter into a plea of guilty, everything stops. We won't even go through the trial process. A conviction will be entered forthwith. So plea bargaining maybe would happen if you've entered a plea of not guilty in the first instance, and you guys have bargained here and there, negotiated here and there, then you decide to change your plea from the plea of not guilty to a plea of guilty. Is that okay, John?
Yeah. Okay. Yeah. Thank you.
Thank you, John. John, I want to encourage you to keep going, keep trying. I like the fact that you have confidence. You want to do what you got to do. You're putting your best feet forward. Just now try your best and supplement it with the notes. Just go through the notes as much as possible, John. You have an idea about the questions that we are asking, but I want to believe that you could delve deeper and that you can do better. All the same, you're on the right trajectory, John.
Thank you. Thank you.
Well, welcome. Okay, guys, it is 11:03. Angelo, I don't know if you have something to say. Then we can go to Hezbon.
I have nothing to say, save to encourage our colleagues that indeed it is possible. I know very soon you will be submitting your coursework, also known as project work, and shortly thereafter you will undertake your orals. So please give it your all. These two examinations are very, very important. Just don't lose hope. And to those who maybe they were participating earlier on and now they are holding back, please keep raising your hands. Okay, like today Lim did, although we did not give him an opportunity. But please just keep on practicing in your small groups, and also here we will try to adjust time so that we can have as many people as possible volunteering, and we will give it our all. We are happy that you guys are studying. I don't believe, and maybe Esbon can concur, we were not actually this better, but I don't know, you guys are really brilliant, and it really encourages us, and we hope to assist as much as we can. So that is all I can say, Daniel. So just keep up, keep the good work. Thank you.
Thank you. Hezbon? Hezbon, are you there? Or maybe you're called. Okay, go ahead.
Yeah, sorry. Sorry, I was saying that on my side, I just have 2 pointers to raise. The first one is that I note with great concern that our colleagues are really doing something, and we can actually attest from the way of responding to the questions, how they are analyzing the questions, the issues we're asking them. And I just like encourage them to keep up. Remember, you guys have less than, maybe for those who will be the first week, you have less than 30 days really to undertake your exercise. So this is the time that you must find that which works well for you. Of course, you have those who thrive in discussions, those who thrive in individual work, but it's important maybe just also get to know what others are doing by attending these sessions or by just asking your colleagues, your friends, so that you know you're on the right track. Other than that, you guys can always continue seeking for the favors, but not for a good panel. Thank you.
Thank you.
And maybe Daniel, before you come in, please guys, this it was a personal experience for me when I was doing my orals, and especially on the aspect of LPM, because at one point or the other, you don't know the panel and that you will actually appear before, and the examinations is 10 marks. So imagine if you appear before, is her name Monday? I don't know, or an LPM lecturer. So I would really encourage us, if we indeed have 30 days to that particular examinations, please try to know something on LPM, because you might not be sure on the kind of panel that you will actually appear before, because it is what we are doing here. It is just to give you that courage, because if you are really prepared, it doesn't matter the kind of question that will be thrown upon you, you'll be able to tackle them. So especially LPM, because there is this tendency of us ignoring LPM, and to a certain extent LWD, probate and administration, trial advocacy, and professional ethics. So please prepare yourself in that regard. So that is what I can add. Thank you.
Thank you, guys. For me, I think I have just a few things to say. As a man thinketh, so he becomes. You guys are going to be the senior counsels of tomorrow. I want to believe that you guys are going to be the judges of tomorrow. You're going to be the justices of tomorrow. Now, this is the process that we have to go through to be that. I want to believe that you guys are the cream de la cream, and I'd like you guys to believe the same. Guys, there's nothing that you guys cannot do. People have gone through these orals, people have done it, and you guys can also do it. Guys, you are the cream de la cream. You guys, you are the judges of tomorrow. You are the justices of tomorrow. You guys are not stupid. You guys are learned. Just use that brain. Just use it. Do not let anything intimidate you. Nothing whatsoever. Believe that you are the best and put in the work. Again, just believing is not enough. You have to put in the work, but have that confidence. You guys are the guys who are going to be leading the Supreme Court in years to come. Meaning you guys are at the top there. You are at the top there. You just have to build it up. The fact that you guys are here, it means that you're in the right place. You've gone through university, you've made it, and today you are here. I just want us to think in that particular way. You guys are the top of this profession. You are not losers, you are winners. So even as you study and prepare for this, don't prepare for this as a loser. Keep having that confidence. If I ask you a question today and you don't know the answer, get back to your books. Try your best to know the answer. If you don't know the answer, then, I mean, the Chief Justice has no information about the answer. Where is this country going to? Where is the judiciary going to? Just try your best and put yourself in those particular situations. You guys are the best. You guys are the best. You are the creme de la creme. You guys are the best. No one should intimidate you. Nothing should intimidate you. Prepare for this thing as the best. Don't be scared of anything. Have that mentality. Read as much as possible. Focus on being competent, and you guys will be fine. This is possible. People have done it. You guys will do it. You guys will do it. So no anxiety whatsoever. Imagine if the Chief Justice was anxious. How would the other judges feel? And you guys are the Chief Justice. You can't be anxious. You guys got to do it. You have to do it. You have to do it, and you can do it. So keep having that energy. And again, just to repeat, just to reiterate, as a man thinketh, so he is. Please, I'm trying to use man also to mean women. As you think, so it is. You guys are the best. You guys can do it. There's nothing that you guys cannot do by the grace of God. So just keep going. Just keep pushing. Have that positive mindset. Do not be intimidated by anything. Keep your confidence. Keep ensuring that you are able to speak correctly. Keep ensuring that you're not using the words, I think, maybe. This is not a situation where you are trying to be safe. There's no need to be safe. Say what you think. Now, when it comes to the provisions of the law, only talk about that provision if you are sure of what you're saying. If you're not sure, there's no harm of saying that the Constitution provides this, that in undecided cases, the court stated this. There's no harm, but there's so much harm in talking about Gitwan versus Taj Mahal and others, yet you're talking about Anaj Warehousing versus National Bank of Kenya. There's so much harm in that. There's so much harm in that. So why you are not sure, just say, in a decided case, the court held this. The Constitution provides this. The CPC provides this. This. But ensure that you are not misguiding or misleading the panelist. Just try and do that. So today, we end with this note that you guys are the best. You are the creme de la creme, and that is it. There's nothing else. You guys can do it, and you will do it. And we believe in you guys. All these guys you see here, Angelo, we believe in you guys. We have conversations about you guys, and we believe that you guys are doing so well. We are so amazed by the energy that you guys are putting in. Keep going, keep pushing. You guys are the Chief Justices of the future. You guys are at the top of this profession. Keep pushing, keep going. I'm going to finish with a word of prayer. Our Father, who art in heaven, Lord, we thank you so much for this evening. We thank you so much for the peace that you have given us. We thank you so much for the energy that you have given us. We thank you so much for this session. We thank you for everyone who has volunteered. Lord God, we thank you for Angelo, for Hezbon, for all of us who keep putting our energy into this particular project. King Jesus, we put this class into your able hands, that may you bless them, that may you lead them, that may you give them peace that surpasses all human understanding, that may they have no anxiety, that may you go before them. May you shine your light upon them, King Jesus. Even as we rest this night, may you be with us. May you guide us. Lord, my Father, their future is yours, and that future is bright. And it is in your mighty name that we pray and believe this night. Amen, guys. Amen. We'll meet again. We'll meet again next Saturday. The recording will be shared in the group. All the best. All the very best. Bye.